I'm Anna Bennett. I'm a partner at Devonshires. My role here is I look after lots of housing cooperative work. If we get queries from housing co-ops, they tend to come to me, and I very much enjoy working with housing co-ops. But I'm here as much as you are to learn from Hetal today, because Hetal is our head of information. And the reason that we're running this webinar is that I've had a few more queries than I would normally expect to see, where members have been asking for subject access requests, for example, and these I tend to move on to Hetal because co-ops are affected by data protection rules, as we all are, and obviously it's slightly more sensitive potentially for co-ops. You know, you are dealing with your friends, with other members, with your neighbours, so it's all quite interesting to see how it all ties together. And Hetal is going to give us all the information about what the law is, what's expected of you, what you need to do to satisfy the requirements expected of you as information holders. So without further ado, I shall hand over to Hetal. I shall make myself off so you don't get distracted by me in the background fidgeting. And I will join at the end in case there's any further questions for me. Okay, thanks.
Right, good morning, everybody, and thank you very much for the introduction, Anna. So as Anna said, my name's Hetal Ruparelia. I'm a partner here at Devonshires, and I also head up our information law team. Now, data protection is very much my bread and butter work. It is an area of specialism for me. It's something that I've specialised in for a number of years. So suffice to say, you are in safe hands with me this morning. I hope that the webinar is informative and you come away with at least a couple of new points that you can share within your organisations, or some learning points as to things that need to be changed within your organisation. So I'm going to kick off with a couple of points which really are quite commonsensical, but I think that they are important in any event. So why are we here today? Why is today's training so important? Well, data protection law sets out what we all need to do to make sure that everyone's data that we are using is done so properly and fairly. You know, as an employee of a co-op, you are responsible for protecting the personal data of anybody who comes into contact with you. This includes your residents, your suppliers, and staff members. If personal data was to fall in the wrong hands, ultimately, people could be harmed. Depending on the situation, they could become victims of identity fraud, discrimination, or even physical harm. More and more people are becoming aware of their personal data and how it's being used. So ultimately, if you're an organization that wants to be trusted, you have to get this right, and you have to keep compliance of data protection legislation at the forefront of your organization. So for any of this training to make sense, we do have to cover off some absolute key definitions within data protection legislation. So the first key definition I want to cover is, we're talking about personal data. Well, what is personal data? Now, I've set out the key definition within this slide, which is contained within Article 4 of the UK GDPR. I'm not proposing on reading it specifically in any detail, other than to highlight that, as I'm sure you can see from this very wordy slide, is that there is a very wide definition of personal data. Almost anything that you are doing relating to an individual, e.g. their address alone, their cookie identifier alone, that within itself is enough to constitute an individual's personal data. So please just, all I would ask that you take away from this slide is the definition is very wide. Almost anything you are doing relating to a living individual will constitute their personal data. Two sort of points that flow from that is that personal data protection legislation does not apply to deceased individuals. nor does it apply to company data. It is only in relation to living individuals. And lastly, any data that has been anonymized also does not constitute personal data, and therefore you do not need to concern yourselves with complying with data protection legislation. Now, that covers, the first slide covers off what I call ordinary personal data, so concerning names or addresses of individuals. Separate to that is the definition of special categories of personal data. And this ultimately covers all sensitive data relating to an individual. So data, this would capture race or ethnic origin, political opinions, religious beliefs, trade union activities, physical or mental health, sexual life, genetic and biometric data. So if you are collecting / processing any of these types of data, there are additional provisions that you must comply with to be able to ensure that you are processing this data lawfully. And I'll go on to expand on that as we go along. So let's look at the data protection principles. Now, these principles should very much lie at the heart of your approach to processing personal data. These principles don't give you hard and fast rules for you to follow, but rather they embody the spirit of the GDPR. Failure to comply with these principles will leave your organization open to very substantial fines from the regulator of data protection, being the Information Commissioner's Office. So it is key that compliance with these principles are at the forefront of your organization. I'll run through them very briefly. The first principle is the one of lawfulness, fairness, and transparency. So for processing of personal data to be lawful, you need to identify a specific ground under the legislation which allows you to process that personal data. I will be going on to look at these lawful grounds in the next couple of slides. The second principle is one of purpose limitation. And this means that once you've collected personal data, or prior to collecting personal data, you should ensure that you're collecting it for a specific, explicit, and legitimate purpose. And thereafter, there can be no further processing of that personal data in a manner that is incompatible with the initial reason for which you collected it. The third principle is one of data minimization, and this ultimately means that you should hold the most minimal amount of data necessary for your purpose. So do not hold on to excessive amounts of personal data. The fourth principle is one of accuracy. All the data you are holding, you must carry out regular data cleansing to ensure that the data you are holding continues to remain accurate. It's not enough to sign a member up some 10, 15 years ago and then not do anything to ensure during that course of period to ensure that data remains up to date and accurate. The fifth principle is one of storage limitation, and this ultimately is saying that data cannot be held on to for longer than is necessary. Now, query here, how long can we justify holding on to data? What is necessary? How do we define that? Ultimately, data protection legislation does not do that work for you. It is for you as the data controller to determine how long you consider it is appropriate / necessary to hold on to specific types of personal data for. That's up to you to determine that, and you ought to be able to justify the time periods that you have ascribed to any given personal data. So just to pause there, all organizations should have a document retention schedule which sets this out. If you do not have this, please do let me know. I can assist with that. But that schedule would give you the retention period and the rationale as to why you are holding on to any given document for said period of time. The sixth principle is one of integrity and confidentiality, and this principle requires you as data controller to have appropriate security measures in place to minimize the risk of a data breach occurring. The last principle is the one of accountability, and this is an overarching principle which requires you to be able to objectively demonstrate compliance with all the principles I've just run through, i.e. principles 1 to 6. And it requires you to ultimately take responsibility for what you do with personal data and demonstrate how you're complying with these principles. There's many ways that you can achieve the accountability principle. A couple of key examples are by ensuring that you've got the appropriate policies and procedures in place relating to your compliance with data protection legislation. So, for example, a policy and procedure dealing with subject access requests, a policy and procedure on how you would manage a data breach if it was to happen. And another way of meeting the accountability principle is by ensuring that your staff are receiving regular data protection training. And the rationale for that is that if and when a data breach was ever to occur, and the ICO was to investigate said data breach, one of the things that the ICO would be asking for confirmation on from you as data controller is, have your staff had regular data protection training? And the reason for that is because the ICO wants to be satisfied that, for example, a data breach occurred because of human error or because of a cyber attack. It's not because the organization is failing to take its requirements under data protection legislation seriously. And it is for this reason that it is very important to be able to demonstrate that staff have received regular data protection training to satisfy the accountability principle. I'm now going to move on to the various bases for lawful processing. Now, what I mean by this is this. For example, when you are signing a member up to grant them a new tenancy, you will be inevitably processing their personal data. You'll be processing their name, their address, their contact details, and potentially any health conditions, for example, that they may suffer from. To be able to process that personal data, you need to be able to rely on one or more, but at least one of the lawful bases that are set out in Article 6 of the UK GDPR. And ultimately, unless you can slot yourself into one of these bases, you cannot process the personal data. So the first lawful basis, and the easiest one, is consent. So in other words, if the individual has consented to you processing their personal data, then that is your lawful basis, and you do not need to worry yourself with the other lawful bases under Article 6. Where you don't have consent, or where consent is not appropriate, and I will go on to expand on consent in a moment, there are other lawful bases that you can rely upon, and they are as follows. First of all, the processing is necessary for the performance of a contract. So where, for example, you are signing up a member to a new tenancy agreement, that is your contract and that is your lawful basis. Secondly, where the processing is necessary to comply with a legal obligation. Third, where the processing is necessary to protect the vital interests of the individual. Or thirdly, where the lawful basis is the organization's legitimate interests. Now, as I said, some of these deserve a little bit more attention than others, and I would suggest that the two that deserve that extra attention is both consent and legitimate interests. So I'll go on to expand on those in just a moment. Now, that slide that I just covered is the lawful basis for all data. Once you've passed that hurdle, if you are processing special categories of personal data. Now, remember, this means any form of sensitive data relating to the individual, and we'll use health information as our example. If you are also processing health information about the individual, you need to also slot yourself into one of the relevant lawful bases on this slide. So you will need to satisfy both slides. Lawful bases for processing special categories of personal data are contained within Article 9 of the UK GDPR. Now, the first lawful basis is once again consent. So if the individual has given consent for you to process their sensitive information, you do not need to worry yourself or consider the other lawful basis. Where you don't have consent, you need to be able to slot yourself into one of these other categories. So the first one is where the processing is necessary to protect the vital interests of the individual. However, this is only where the individual is incapable of giving consent, so a very high burden to be satisfied there. The second is where the processing is necessary for the establishment, exercise, or defense of legal claims. So where, for example, you're taking legal proceedings against an individual and you need to reference a disability, for example, that the individual suffers from as part of your legal proceedings, your lawful basis there is the third bullet point, establishment, exercise, or defense of legal claims. So it doesn't matter that you don't have the individual's consent because another lawful basis applies. The third lawful basis is where you can justify that the processing is necessary for the reasons of substantial public interest. Now, to understand what falls under reasons of substantial public interest, you need to cross-refer to the Data Protection Act 2018, which sets these out. But for our purposes, the relevant ones would be, for example, where the processing is necessary for safeguarding reasons or for the prevention or detection of crime. Now, there are various other ones. I've just highlighted the ones which are probably more relevant to you than others. So I'm just going to expand slightly on consent as a lawful basis for processing. Under the UK GDPR, there is a very high threshold to be able to demonstrate that effective consent has been obtained from your data subject. So consent means any freely given, specific, informed, and unambiguous indication of his or her wishes by which the data subject, either by a statement or by a clear affirmative action, signifies agreement to personal data relating to them being processed. I appreciate, again, very wordy definition, but the key points are as follows. Where you're relying on consent as your lawful basis, the burden of proof on demonstrating that appropriate consent has been obtained is on you as the data controller. You cannot rely on implied consent. Secondly, consent cannot be relied upon where there is a significant imbalance between the parties. So, for example, you cannot make it a condition of doing something else. For example, being able to enter into an employment contract. That is not appropriate. So for our purposes, under the old legislation, so that was the Data Protection Act 1998, at that time, what we would see is a lot of tenancy agreements, including a sort of catch-all consent clause within the body of the tenancy, ultimately giving the landlord consent to process the individual tenant's personal data. And what used to happen in those circumstances? Well, the tenant would be presented with that tenancy agreement and they would sign on the dotted line. But the reality being they weren't signing specifically in relation to that consent provision. They weren't necessarily giving full consent. They were signing that tenancy because they wanted the accommodation. And what the new legislation, it's not new anymore, but what the UK GDPR has done, has said that is no longer an acceptable form of obtaining consent. It has to be independent to any other contract, and you can't make it contingent on entering into a contract. It's got to be entirely independent. And the third point I want to highlight with respect to consent is that an individual data subject has the right to withdraw their consent at any time. They do not have to give any rationale for that. If you are relying on consent as your lawful basis, do take note that the individual does have the right to withdraw their consent at any time. And at that stage, unless any other appropriate lawful basis applies, which has been communicated to the data subject from the outset, you will have to stop processing their personal data. The last point I want to highlight is that consent can't be hidden in the small print. You can't rely on any pre-ticked boxes, any opt-outs, or consent by default. So just to summarize, the burden for obtaining effective consent is very high. The second and last lawful basis that I want to just expand on slightly is legitimate interest. Now, ultimately, there is a lot of processing of personal data that you do as an organization where it is entirely lawful, but you might just not know the name under which you are relying upon under Article 6 to justify that processing. And in a lot of circumstances, the relevant lawful basis is going to be legitimate interest, because this ultimately covers a lot of actions that you undertake as a business when you're processing personal data, provided that you don't cause unwarranted interference with the rights and freedoms of the individual. So when you're thinking of legitimate interest, there's always a three-part test that you should apply. The first part is a purpose test. Are you pursuing a legitimate interest? The second part is a necessity test. Is the processing necessary for that purpose? The last part of the test is a balancing test. So do the data subject's interests override the legitimate interests? Now, by way of small example, a lot of landlords issue, for example, quarterly newsletters to their residents concerning, whatever's going on within the organization, anything that the landlord wants to bring the tenant up to speed with. And a lot of times these newsletters are sent out to residents by email. So, by relying on the resident's email address. So if we pause there for a moment, if you are sending an email to your resident, you are processing that resident's personal data. Their email address is their personal data, and so it amounts to a form of processing. So to be able to do that, e.g. send a newsletter out by email, you need to be able to rely on one of the lawful bases under Article 6. And I would suggest in that instance, the relevant lawful basis that you're relying upon is legitimate interest. And why is that? So let's just briefly work through this test. Are you pursuing a legitimate interest in this example that I'm giving? Yes, you're looking to issue this newsletter by email so that, like I said, you can let the resident know of any sort of pressing news within the organization, anything they need to be aware of, any events that might be coming up. Necessity test, is the processing necessary for that purpose? Arguably, yes, unless you send it out by email or post, for example, to that resident, it's not going to come to their attention. Lastly, are you doing anything with that resident's personal data that they would not expect you to do? Are you going to cause them an interference? And I would suggest on balance, no, they would expect to see this form of correspondence and news from their landlord. So in that example of issuing a newsletter to a resident by email or to their postal address, the relevant lawful basis would be legitimate interests. I'm now going to touch upon the rights that data subjects have over their personal data. And the first right and the key right, and the right that's probably going to hit your desks more than any other right that is afforded to a data subject under data protection legislation, is what's called the right of access, also known as subject access requests. Now, For those of you who have not yet had to deal with a subject access request, what a subject access request means is that a data subject has the right to request copies of all the personal data that you are processing about them. They don't need to give you a reason for this. They, generally speaking, do not need to pay you a fee. They do not need to make the request in writing. It can be verbally. They don't need to make the request to a specific individual within the organization. It could be sent to any employee in the business. It could also be by any form. So in other words, if you have a social media page, by way of example, they could make the request via the social media page, and that would still constitute a valid subject access request. Now, for anyone who has had to deal with a subject access request, suffice to say, it really can be quite a burdensome task, particularly if they've been a member of staff or a resident for a particularly long period of time. I will also just pause there and just highlight that to make a subject access request, you don't have to be the organizer, you don't have to be a resident, you don't have to be an employee. It can be any individual who has had contact with the organization. So for example, like a prospective tenant who wasn't ultimately granted a tenancy would of course have the right to make a subject access request. Now, there are specific exemptions that apply to subject access requests. And if an exemption applies, then that would mean that you don't have to comply. Now, a lot of these exemptions are really specific, and they are contained within the Data Protection Act 2018. There are some exemptions that I would highlight as being more applicable to you than others. The first is legal privilege. So where, for example, an individual has made a subject access request, but you have sought legal advice about said individual. And for example, within the file on this specific individual is this legal advice about them. Of course, just to say that legal advice does not need to be disclosed as part of the subject access request because it is privileged and there is a specific exemption that accounts for that. And the second sort of most relevant exemption is where the data about the individual who has made the request would also capture another third party's data. So for example, if resident A has made a request and in disclosing resident A, some records would also identify resident B, in that instance, you do not have to disclose that data. So they are really quite specific and do require quite careful consideration as and when you receive a subject access request. Independent to those specific exemptions I just mentioned is another all-encompassing exemption that's contained within the UK GDPR, which specifies that where an individual makes the subject access request, which is manifestly unfounded or excessive or repeated, you can either charge a reasonable fee to respond, or you can refuse to respond. Now, manifestly unfounded, I'm sure, again, you can see from the terminology, very high threshold to meet, to be able to justify relying on the same and therefore not complying with a subject access request. But manifestly unfounded within itself is not defined within the legislation. However, there is some guidance that's been published by the ICO, which ultimately is saying that you need to consider what the intention of the data subject is in making the request, in that if the intention is to ultimately harass the organization, or where, for example, a data subject is making a subject access request, but says to the organization, if you do X for me, for example, you agree to a management move that's been denied previously, for example, if you do X for me, then I will withdraw my subject access request. In that instance, we may have enough to argue that the request is manifestly unfounded, and therefore you do not need to respond, i.e. you do not need to comply with the subject access request, or you can charge a reasonable fee. I just also want to highlight that when you receive a subject access request, you must comply without undue delay and in any event within 1 month. However, this deadline can be extended by a further 2 months if the request is complex. The second right that I want to highlight is the right of erasure. And what this means is that an individual has the right to request from you as data controller to have their personal data erased, but only if one of these specific conditions apply. So, for example, if the personal data is no longer necessary for the purpose in which you originally collected or processed it for, then a relevant right of erasure could be applied. Secondly, where you're relying on consent as your lawful basis for holding the data and the individual withdraws their consent. And lastly, if you're relying on legitimate interest as your basis for processing, the individual objects to the processing of their data, and there's no overriding legitimate interest to continue this processing. So if one of these conditions apply, then you do have to delete the personal data that you hold about the individual. There are exemptions to this. So again, if you receive a right of erasure request, do consider whether one of the exemptions apply. In this instance, you again have to comply without undue delay in any event within 1 month, but this deadline can be extended by a further 2 months if the request is complex. And the last right I want to highlight is the right of rectification. And what this means is that if an individual considers that the data you are holding about them is inaccurate or incomplete, then they can ask for you to rectify the data that you hold about them. Where such a request has been made and you have rectified your own records, you are also obliged to contact any third party with whom you've disclosed that personal data with. And again, you must respond without undue delay within 1 month, and this can be extended by a further 2 months if the request is complex. Right, now swiftly moving on to data security. Now, as an organization, I can only assume that you are processing really vast amounts of personal data and accidents occur. So where you are processing personal data and you've accidentally disclosed one party's data to another party, or you have destructed that data, you've lost the data, any form of unauthorized disclosure, all of these would amount to a data breach under the UK GDPR. Once you have identified that a data breach has occurred, there's lots of things that you need to consider. The starting point is, please make sure as an organization you have an appropriate data breach policy and procedure in place so that your staff know what to do as and when a data breach occurs. They will occur, despite however careful an organization may be, just based on quantity alone, it is inevitable that data breaches will occur. And the reason it's really important to get this right and to ensure that staff know what to do when a data breach happens is because under the legislation, you are required to notify the ICO, the Information Commissioner's Office, about a data breach within 72 hours of it occurring, unless the breach is unlikely to result in a risk to the rights and freedoms of the individual concerned. So very, very tight timescale. 72 hours is also not working days. So, if a breach happens on a Friday, you've only got until the Monday to report it. There are quite significant implications if you fail to follow this process. So obviously each breach needs to be identified, independently. And the sorts of things you need to be thinking about to decide whether you need to report it to the ICO or not is what could potentially flow from this breach. Is there a risk of identity fraud? Is there a risk of discrimination? Is there a risk of physical harm? In these instances, you must report the breach. If the breach occurs, which you've determined does not need to be reported, you are still required by the legislation to keep an appropriate record of all the data breaches, regardless of whether you report. So, ultimately, you do need to be able to detect, investigate, report, and document any data breaches swiftly. If you are ever in doubt as to whether a breach needs to be reported, again, I can help you. I can help run through sort of the thought process with you and assist you in making that decision on whether it needs to be reported or not. If you're going to take something away from this training, take this away. Compliance with data protection legislation, it isn't something to be taken lightly. The penalties for failing to comply, with the principles, for failing to deal with a subject access request appropriately, for failing to manage a data breach as and when it occurs. There are really significant penalties that could flow from it. And the highest sanction is a monetary fine of £17.5 million or 4% of the organisation's turnover, whichever is the highest. Now, the ICO, of course, doesn't necessarily jump to monetary fines. It does have other enforcement action it can take against an organisation. This includes things like reprimands, enforcement notices, but just take note, all of those other enforcement mechanisms on balance will be published. So, if you are investigated and an enforcement notice is issued against you, said notice is going to be publicly available on the ICO's website. So, of course, that does have the potential so really negative publicity. So, just please do note the significant implications that can flow from the lack of compliance with data protection legislation. I'm just going to finish off my session by just briefly touching on some recent case law. The rationale for doing this is just to hopefully bring to light a little bit of sort of the boring law that I've explained so far. So the first case is the case of Driver and the CPS. Now, in this case, the CPS disclosed details of an ongoing fraud investigation named Operation Sheridan concerning a Mr. Driver in an email to a member of public called Mr. Graham. Now, Mr. Graham was not involved in the investigation, but he was described in the judgment to be a political opponent of Mr. Driver. Mr. Graham made an inquiry with the CPS relating to Operation Sheridan and asking for an update on the same. And he was sent a response from the CPS, which said a charging file has been referred from the Operation Sheridan investigation team to the CPS for consideration. Mr. Graham then communicated the contents of this email with his own comments, which included naming Mr. Driver to several further individuals. Now, as a result of this email being sent by the CPS, Mr. Driver brought a claim against the CPS on the basis that the email caused him distress, and he relied on breach of data protection legislation, the common law right of misuse of private information, and the Human Rights Act 1998. Now, the Data Protection Act 2018 enables data subjects to be compensated if they have suffered material or non-material damage as a result of an unlawful processing operation. His claim for distress was successful, but it was caveated for the following reasons. Firstly, to support his claim for distress, he relied on the fact that he visited his doctor in 2020 and was prescribed anti-anxiety medication. However, the judge saw no evidence that the data breach was the specific cause of Mr. Driver's anxiety. The second point was that the judge was skeptical of Mr. Driver's claim about the extent of the distress, denying that the data breach could have reasonably caused the claimant anything like the anguish which he claimed. But the key point is this, that he was awarded damages for this data breach, and those damages were £250. Now, you may be thinking, oh, well, that's really not that bad, you know. An email was sent, it shouldn't have been sent, but CPS was only ordered to pay £250. But, of course, legal costs would have flowed from that, and those would have been substantial. So it's £250 in terms of damages and compensation, but the CPS's liability with respect to covering Mr. Driver's legal costs would have been, of course, very substantial. But overall, I do think this case does provide very helpful guidance in that a case involving a data breach which has limited disclosure of personal data and limited distress being suffered, £250 is an appropriate figure for damages, or at least a good starting point. So, you know, if you're ever engaged in a data breach and you receive a claim for compensation as a result of the same, do think about trying to settle that as early as possible based on this case so that legal costs do not start to escalate. The second case that I want to highlight is a fine that was issued by the ICO following a cyber attack. So I just want to highlight this case because it demonstrates to you what the ICO, you know, what the ICO does and what levels of fines that it levies when a data breach occurs. So in this case, which concerns a fine of £4.4 million following a cyber attack. So the fact pattern is as follows. In this case, an employee forwarded a phishing email to another employee. That email was not quarantined or it wasn't blocked by Interserve's system. And this resulted in malware being installed on the employee's workstation. Ultimately, this meant that the hacker had access to 283 different systems and 16 accounts. And they also uninstalled the company's antivirus solution. What did this mean? It meant that the hackers had access to personal data relating to 113,000 employees, and said data was rendered unavailable. The types of personal data this included was details of national insurance numbers, bank account details of employees, but also special category information that I referred to at the beginning of my training session, including ethnic origin information, details of disabilities, and sexual orientation. The ICO determined that Interserve failed to follow up on the original alert of the suspicious activity. It was using outdated software systems and that it had a lack of adequate staff training and insufficient risk assessments. I find that this statement that was made by the ICO to be really powerful, and it's as follows. The biggest cyber risk businesses face is not from hackers outside of their company, but from complacency within their company. If your business doesn't regularly monitor for suspicious activity in its systems and fails to act on warnings, or doesn't update software and fails to provide training to staff, you can expect a similar fine from my office. So the key takeaways from that case is to ensure that you're refreshing cybersecurity training for all employees at all levels of the business, that you're taking an active approach to training and to make sure it's ongoing. So, for example, sending regular phishing emails to staff to test cyber resilience, and to ensure that the IT infrastructure and operating systems are checked and updated regularly. And really briefly, the last decision is, and again, another decision of the ICO against the city law firm of £98,000. In this case, there was a ransomware attack, which resulted in a hacker having stolen almost 1 million files from Tucker solicitors. The ICO found that Tucker solicitors had breached one of the guiding principles that I referred to at the beginning of my training, namely the security principle, in that they failed to have adequate cybersecurity measures in place to protect client data. The hacker was able to infiltrate an app that the firm was using to facilitate working from home arrangements. The ICO determined that the app was not sufficiently secure as it did not have an MFA function. Tucker should not have allowed access to its network using only a single username and password. And the ICO, highlighted that it's really important that systems are in place to facilitate remote working so as to ensure that data is appropriately protected. So just to summarize that, in that instance, £98,000 was the fine that was levied to Tucker's solicitors. I appreciate I've covered a lot of information there. Apologies if I was going quite quickly towards the end. I just wanted to ensure that we saved time for any questions that you may have for me. I hope that's been helpful so far.
Yeah, thanks so much, Hetal. I thought that was so clear and laid everything out so well, because it is a bit of a minefield. There is a question I've seen from the audience, but also I've got a question, or a couple of questions. I've got a very simple question first, and then a slightly more complex type situation. So the first question, because you mentioned newsletters, so my ears pricked up because I'm a simple soul, so I can understand this. But when members are sending out, say, minutes, right, or because they will be, management committees will be sending out the minutes, they will send them out to everyone on the list. I mean, would you blind copy those email addresses just in case people don't want their email address? Is that something that you would do as a practical measure, for example, just to stop that sort of cross? It's very easy, isn't it, just to send the
absolutely. Yeah. And I think that's a really good point. And so the simple way of looking at that is this: is it necessary for each of those members to have access to each other's email addresses? Yeah. And to the extent that the short answer is no, it's not necessary, you can't justify including everyone's email address in the body of one email. That there's no justification in that instance.
Yeah. And another one, I mean, I'm not naming names, but one of my, I've got a case at the moment with a housing co-op client, and it's slightly worrying because obviously housing co-ops obviously are all members. You do a lot of the work voluntarily. If you're managing, you're generally the more active people. It's all wonderful. But in this instance, the co-op's lost a lot of information because the person who's a chair, they've all fallen out, and the person who was the chair had lots of the minutes and so on their personal computer. So that's all disappeared now, which is obviously awful for the co-op in terms of trying to find that information, but also presumably potentially a breach, is it?
Absolutely, there is definitely a potential breach there, but oversimplifying that specific example, and Anna and I have collectively advised there's really got to be a huge emphasis on separating out the use of personal email addresses. And it's not just for this reason highlighted, but if you were to receive a subject access request, in that instance, because so much is sitting on these personal email accounts, they're not sheltered. So there's going to have to be an audit of all these personal email addresses to collate the relevant information for the subject access request. So there does need to be a lot of work to try and ensure that members are not using personal email addresses for co-op business.
Yeah, and one thing, just an observation, internally, I was quite shocked when Hetal pointed out that basically, if a hacker gets into your system, they can get all of your inbox or your sent items very easily. So it's very important to file things away and keep it in a secure, which I don't know anything about, but that's an IT thing. But that's the answer there as well, isn't it? I have no idea about that.
Absolutely, and it is an IT thing, but it also isn't, Anna, in that if for example you and I are sitting with an inbox of 1,000 emails and they haven't been appropriately filed away, that's a matter for us, in the event that, every employee has got to take sort of, a level of responsibility as far as trying to achieve compliance with the legislation.
Yeah, there are a couple of questions. I don't know if you can see them on your screen.
Yes, I can.
Okay.
So the first question, does legal privilege have anything to do with antisocial behaviour issues? So if I may sort of read between the lines there, if the question is saying, that there is an issue relating to ASB concerning a particular member, and legal advice has been sought in relation to that ASB and potentially recovering possession of the property. If that member then makes a subject access request and, for example, says, I want my whole file, any information that you hold about that individual, which is containing legal advice, so emails between you and your solicitor saying, I've got this troublesome member, they've engaged in this behavior, what can I do? Any advice you've received in that regard does not have to be disclosed to that resident because legal privilege is attached to that information. So I hope that answers that question, but do clarify if I've misunderstood that question at all. The second question, 2 committee members visited a tenant regarding a disrepair claim and recorded the visit on a mobile phone. The tenant has asked for a recording of this. Is she entitled to it? Yes, she is, in that that recording is that individual tenant's personal information. So even if, for example, the recording was not physically on their face, and let's say it was just a voice recording, that voice recording within itself constitutes that individual's personal data, and therefore would be entitled to a copy of the same. I think that question is an important one, in that it just reminds me to make one point, which I haven't clarified so far, but is an important point. Where an individual is making a subject access request, by no means do they have to use that terminology. So they don't have to say, I'm making a subject access request, or they don't have to refer to the legislation. Just them saying, I want my data, or I want a copy of my data, or I want a recording, or I want an email that I know you have about me, that constitutes a subject access request. And the obligation is on you as data controller to understand that said request amounts to a subject access request.
And also, if I could just add, if that's a disrepair claim, they'd be entitled to it by way of disclosure anyway, pre-action disclosure under the pre-action protocol for housing conditions claims, because it's information essentially, although it's not on paper, it's still a documentary information about what was found. And it's not necessarily in anyone's interest not to withdraw it unless something terrible happened. it'll be on record, presumably everyone was there, so it's good to have it. There's no more questions on here. Thank you so much, Hetal. I thought that was so clear, and I really hope the participants enjoyed that. If you have any more questions, you've got Hetal's details at the end of the slides, which will be sent out afterwards. Once we are zapped or we leave, so hopefully we won't be zapped just yet, but after we've left, you will be sent a feedback form. So if you fill out that and just give us a bit of feedback, very importantly, especially for co-ops, as we don't get the chance to chat to you directly that often, if there is anything on the co-op side that you want more training on, or you think you'd benefit from, then please let me know when we do read those forms. So thank you so much for attending today. Thank you, Hetal.
No, my pleasure. And I would just add, if any of you want me to, provide this refresher training to your organisation directly, then I'd be very happy to do so. Or if you need any of your policies and procedures revisited or even drafted afresh if you don't have them, which is a key that you do, then please, again, do feel free to reach out.
Okay. Thanks, everyone.
Thank you, everyone, for your time.